Good afternoon. I'm Catherine Saldana, mentor attorney with the Dallas Volunteer Attorney Program. Thank you for joining us today with our Landlord Tenant Issues 101 CLE. Before I introduce our speaker today, I would like to talk about our program, the Dallas Volunteer Attorney Program, for those of you who may be unfamiliar with what we do. It's a joint project with Legal Aid of Northwest Texas and the Dallas Bar Association. We hold several intake clinics monthly, we did pre-COVID, and we have strict financial eligibility guidelines for our clients. So to give you an example of our low-income clients' income, it would be a family of four is about $33,125 a month. Annually, or $2,700 a month. A single person would be $16,100 annually, and about $2,000 a month. So as you can see, it's not enough money to live on, let alone to cover any legal expenses that they may have. The majority of our cases are family law. We do, and most of those are divorces. And but we also do consumer, landlord tenant especially, and we do roof repairs, that kind of thing, and as well as employment, unemployment issues, Chapter 7 bankruptcy, and Chapter 13 bankruptcy. We refer to our legal aid consumer division. We are fortunate to have Kalisha Rutledge speak with us today. She is a managing attorney for the Home Preservation Project of Legal Aid of Northwest Texas. In our Dallas office, she has been with LANWIT for the last 10 years and specializes in landlord tenant law and guardianships. She has served as a mentor to other attorneys on several task forces, and also as the LANWIT's housing practice team leader for the past 3 years. And she has been a frequent speaker with UNF on several of our consumer CLEs. In recent months, she has helped coordinate community education for tenants facing evictions by doing outreach at the courthouse. Please join me in welcoming Kalisha.
Hello, and sorry guys, I didn't turn my phone off, but let me do that right now.
Hey, Kalisha, you went on mute.
Okay, can you guys see my screen now? Yes?
Yes.
Awesome. Okay, so today I'm going to be talking about a lot of different issues in an hour span, so I might kind of gloss over some things, but it's my understanding that the PowerPoints have already been provided to you guys, and I put the section numbers for each different topic where you can find it. So hopefully, if I do go over it really quickly, you have the section number where you can go and read up on it. So we're going to get started, and the first thing we're going to be talking about is repairs. In the repair section, the codes are going to be the property code section, or chapter 92.051 through .062, and the Texas Rules of Civil Procedure Rule 509. So with repairs, a landlord has a duty to make repairs to a unit. The tenant, to make those repairs, what they need to do is they need to give the landlord a notice where they pay their rent. So if they pay their rent in person in the office, they can take their rent repair request into the office. If they mail it, then they can mail it to the landlord, but it definitely, you should always put it in writing. And I don't mean an email or a text message. I mean a piece of paper that says repair request. I need the following things repaired. I need my toilet repaired. I need the kitchen sink repaired, and put it actually in writing. It's always recommended that you send that written repair request via certified mail return receipt requested, or a way that you can track it when the landlord actually receives that notice. Now, there are some apartment complexes that ask you to put your repair request into the tenant portal. If you do that, I would just make sure you can either get a screenshot of it or actually go into the office and get a copy to show that they've actually received that repair request that you put in through the portal. If you give the landlord a notice in writing, if you send it one time via certified mail return requested, that's all you have to do. If you give them a handwritten note and you hand deliver it, you would have to give them that first notice. You would need to wait the number of days that is required to give the landlord an opportunity to make those repairs, and 7 to 10 days is a reasonable amount of time. If you send it in writing, you only have to send that one letter and they have 7 to 10 days to repair it. If you give them a handwritten letter or a typed up letter via hand delivery, you have to give them that first letter, hand delivery, wait 7 to 10 days, and then give them another letter, which is then going to give them another 7 to 10 days to do it. So that's why we always request that people just go ahead and send that first repair request in writing via certified mail or a way that you can track it. To get those repairs made, the tenant has to be current on rent when they give the notice of repairs. Have to be current. If they're not current on rent, then that landlord technically does not have to make repairs to their unit. And the repairs that need to be made are repairs that are going to materially affect the physical health or safety of an ordinary tenant, or is something that is due to the landlord's failure to provide hot water. So the next slide is when the landlord does not have a duty to repair. If the tenant breaks a window, the landlord is not responsible for making that repair. That repair is the tenant's responsibility. Or if a tenant's guest comes over, or one of their small children, or an invitee, if they are the reason why there's damage to the property, then the tenant is going to be responsible for that damage, unless it's something that's normal wear and tear. Now, if your kid has a crayon and they're marking all over the walls, that's not normal wear and tear, and that's something that the tenant is going to have to be responsible for. If there is something that happens that a third party did, like say some neighborhood kid came and threw a rock through the window and broke the window, then that would be the landlord's responsibility, because it wasn't the tenant's fault that happened. It was an outside person's fault. Like I told you guys, a reasonable time to make those repairs are 7 days from when the landlord actually receives the notice. But if the landlord is going to take longer than 7 days to make those repairs, then they're supposed to provide the tenant a written explanation of why they're delaying after 5 days. A lot of landlords do not do that, so you can ding them for that at the end. The landlord receives that repair notice either when they receive it or when the post office tries to deliver it. So if the tenant was current on rent, it wasn't their fault that the repair needs to be made, and they sent the letter, they sent it via writing, certified mail return requested, the landlord received it, 7 days have passed and the landlord has failed to make that repair that affects their health and safety, the tenant then has a couple of options. They can terminate the lease agreement, but if they do that, then they need to move out immediately. They shouldn't wait a whole month to move out. And they can get a pro rata refund when they're moving out if they've paid rent. They can get their security deposit returned, or they're going to get whatever damages that they owe to the landlord would get deducted from that security deposit, and then the landlord should return the rest of the security deposit. And also, you would want to make sure that the tenant sends the landlord a letter like, hey, I asked you to make these repairs. I sent a certified mail receipt requested. I waited a reasonable amount of time for you to make these repairs. You did not make the repairs, so I'm terminating this lease agreement effective October 26th, and I'm moving out. You want them to send a copy of that letter to the landlord so that the landlord can be on notice that they've terminated the lease agreement. And you want to make sure the tenant keeps a copy just in case the landlord comes back and says that the tenant broke their lease agreement, which isn't really true. They terminated because the landlord didn't make the repairs needed. You can also have the tenant make repairs and deduct that from the rent. I never recommend this to anybody to do because it's very detailed. And if you miss a step, then you are going to be liable to the landlord because you didn't follow the rules correctly. So I would never tell anybody to make their own repairs and deduct it from their rent. The third thing you can do is file a repair lawsuit in JP court to force the landlord to make the repairs. If the tenant does the repair process wrong, then the tenant can be liable to the landlord for damages. That repair lawsuit, like I said, is filed in JP court. If any party loses, that party can appeal the judgment, and you'll just have a new hearing in front of a whole new judge in county court. And there are no counterclaims allowed in repair lawsuits. The next thing I'm going to talk about is utility cutoffs, and that is covered by the property code section 92.008. And so when we're talking about utility cutoff, we have to ask ourselves, who is providing this utility? Is the tenant paying the landlord for utilities, or is the tenant paying an actual utility company? If it's a utility company and the utilities were disconnected for non-payment of rent, then that is allowed. The electric company does not have to provide you free electricity if you don't pay. There are some programs now due to COVID that tenants can have access to. But if the utilities are cut off by the actual utility company for a non-payment of rent, that is allowed. Now, there becomes an issue when the landlord turns off utilities that the tenant is paying them. Say that it's all bills paid and the tenant doesn't pay their rent for October and the landlord goes and gets their electricity cut off. The tenant is paying the landlord utilities, and then the landlord takes that money and pays the utility company. If the landlord tries to cut off the utilities that for non-payment of rent, that's not allowed unless there is a written agreement, a written lease agreement that provides for that disconnection. Landlords cannot cut off tenants' utilities unless it's for a repair or an emergency. If it's for non-payment of some type of rent, then what the tenant can do is the tenant needs to call that landlord and say, hey, you cut off my electricity. I know I didn't pay my rent, but you can't just cut off my electricity. That's not allowed. If the landlord does not do that, then the tenant can go to JP court and file what's called a writ of restoration. If, on the other hand, there is a written lease agreement and there is a disconnection of utility clause in the lease, then the landlord has to follow that section to the T, or else they're going to be responsible, or they're going to be liable to the tenant, and the tenant will be able to do a writ of restoration. Landlords usually do not get this right, and the tenant can then file a writ of restoration, which is the next slide. So writ of restoration is covered by section 92.01 of the property code. And this is basically a lawsuit that the tenant goes to JP court. Mostly all of the tenants' remedies, the lawsuits that they can file are going to be in JP court in the precinct where the property is located. So they go down to JP court and they can tell the clerks, you know, I want to file a writ of restoration because my landlord cut off my utilities. The clerks of the court should have copies of writs of restorations that the tenant can just fill out and turn in. Tenants can also file any lawsuit for free if they fill out a statement of inability to pay court costs and they attach it along with their petition. They can file any lawsuit for free. So that's what I would recommend that they do so that they don't have to pay money to file a lawsuit to get their utilities cut off. To get their utilities cut back on, because the reason why their utilities got cut off were probably because they couldn't pay their rent. So a statement of inability would cover that. In the writ of restoration, the tenant is going to be basically signing and filling out the form that says, I live in apartment 101 at this location. and my landlord cut off my utilities without cause. It wasn't for a repair and it wasn't for an emergency. They literally just cut off my utility. The judge would usually have an ex parte hearing that day, right then, if he's available to hear that case. And he will basically either sign the writ saying, you know, yes, the landlord needs to turn your utilities off, or he's going to sign an order basically saying, no, I don't think you're a tenant and that you are basically able to get this remedy. The landlord, and what'll happen is, say the judge says, yes, you know, your landlord turned off your utilities, you know, in violation of the property code. What they'll do is they'll give that order to a constable, and the constable will go to wherever the landlord is. If it's the property company, they would go to the property company, and they would basically serve that landlord with a copy of the petition and a copy of the order, basically saying you need to turn these utilities back on. And if you don't turn these utilities back on, you can be held in contempt of court. The landlord does have an option to request a hearing since the writ of restoration was ex parte. The landlord has to request that hearing within 7 days of being notified by the constable that a writ was filed. If there's no hearing requested within 8 days, or then the tenant can also get a judgment for court costs against the landlord if they don't request a hearing. Either party can appeal a writ of restoration just like they could appeal an eviction, and we'll talk about an eviction later. If a writ of possession is issued in an eviction, it's going to supersede a writ of restoration. So basically, if you get evicted and a writ of possession is issued, with basically is a court order signed by the judge saying, yes, go ahead and remove this tenant and all their belongings from the property. That's going to supersede if a tenant files a writ of restoration saying, hey, turn my utilities back on. If you're getting evicted, there's no need for you to have utilities. So that's why it's going to supersede the writ of restoration. So next, we're going to be talking about the wrongful lockout. And that's covered by the Property Code Section 92.0081. So a wrongful lockout. A landlord cannot intentionally prevent a tenant from entering leased premises except by judicial process, i.e. an eviction, unless it's for a repair, construction, emergency, if they're going to be removing the contents of an abandoned unit, or changing the locks for a tenant delinquent in rent. A lot of times, a landlord might not lock someone out. They might just, you know, take the door off the hinges. We've had applicants where the landlord just literally took their front door off the hinges. And that's in essence basically locking them out because they can't get in and out, or to protect their stuff. You can't remove the door, remove door hinges. You can change the locks of a tenant that's delinquent in rent, but there are certain protocols that you have to do to actually change those locks. So the examples or circumstances when a landlord can lock a tenant out or change the locks, if it's in the lease agreement and the tenant is delinquent in rent, the landlord has to first mail out a notice 5 days before the lockout, or they can hand deliver or post a notice 3 days before the lockout on the inside of the front door, not the outside of the front door, because anybody in the apartment complex or in the neighborhood can go and they can take notices off the front of the door. That's why landlords are required to post any notices on the inside of the door. The notice saying that they're going to lock a tenant out, it has to include the earliest date that they're going to lock that tenant out, the amount of rent that the tenant has to pay to prevent the lockout, the name, address, and location where the rent can be paid or discussed. And this has to be underlined or bolded in the tenant's the tenant's right to receive a new key at any hour, regardless of if they pay rent or not. So even if they get locked out or the locks are changed for non-payment of rent, if that tenant calls the landlord has to provide that tenant a key, no matter if they pay rent or not. So if you're locked out if the landlord actually does follow through with the lockout, what they're gonna do, say they've changed the locks, so now your key doesn't work. They are gonna put a notice on the front of your door that basically tells you where you can call 24 hours to get a new key. And that number has to be answered at any time within that 24-hour span. The tenant needs to wait at least 2 hours from the time that they call the number for the landlord to come get a key, because the landlord has a 2-hour window to deliver that key to them. If the landlord comes and the tenant is not there waiting on the key, then the landlord can leave and the tenant's going to have to wait until the office is open for normal business. If the tenant calls and the landlord does not come out within that 2 hours, then there's a remedy for the tenant to file a lawsuit against that landlord. The notice also has to say the amount of rent and charges that are due. So they have to put a notice on the inside of your unit before they actually do the lockout. And when they do lock you out, they have to put a notice on the outside of the door letting you know where you can call to get a key to get back in. So if the landlord violates any of that section, the tenant can recover possession of the premises or terminate the lease agreement, and they can get a civil penalty of 1 month's rent plus $1,000. Actual damages that they are incur, court costs, or attorney fees minus any delinquent rent that they owe. And this provision cannot be waived by the parties in a lease agreement. So a writ of reentry, that's the remedy that tenants can file if they are locked out of their unit illegally. And that's covered by section 92.009 of the property code. So if that tenant was locked out, they can go to JP court and they can file a lawsuit, and they can file the statement of inability to pay so that their lawsuit, they can file it for free. They're going to have an ex parte hearing also in front of the judge that same day if the judge has time. And they're basically going to tell the judge, hey, yes, I didn't pay my rent. They locked me out. Yes, it's, in my lease agreement, or no, it's not even allowed in my lease agreement. I called the number. I waited 2 hours. They didn't give me a key and I need to get back into my unit. If the judge believes the tenant, then he can issue an ex parte judgment that's going to let the tenant back in the home after that hearing. And the court is going to serve a petition and the order on the landlord that basically says you need to let this tenant back in. And if you don't, you can be held in contempt of court. The landlord has a right to request a hearing, of course, within 7 days of being served. Either party can appeal a judgment to county court, just like an eviction. And a writ of possession is gonna supersede a writ of reentry, of course. If you're getting evicted, then there's really no right for you to be getting back into your apartment because there's an actual eviction judgment against you. If the landlord fails to obey the court order, they can be held in contempt. But if a tenant files a lawsuit in bad faith, the tenant could be liable to the landlord for actual damages, 1 month's rent, or $500, whichever is greater, attorney fees, and court costs. The next thing we're going to be talking about is a landlord lien, and that is covered in the Property Code, Chapter 54.041 through 048. And a landlord's lien is basically a landlord can have a lien for unpaid rent against non-exempt property that the tenant has in their residence or that is stored in the storage room. It has to be in a written lease agreement, and is not enforceable unless it is bold in bold print or underlined in the lease agreement. And this right also cannot be waived by the parties in a lease agreement. There is no notice required for the landlord to exercise a landlord's lien, as long as, and that's why they wanted it bold or underlined in the lease agreement, because that is basically your notice that you are signing a lease agreement that includes a landlord lien provision. This is the only notice that we have to give you before we actually go in and remove the property. So there's no notice that the landlord has to give them that they're going to exercise the lien. The landlord does have to enter peaceably. They can't force their way into the unit. And when they do exercise the landlord's lien, they have to leave notice in the apartment that they have done so. And that notice is going to include a list of the items that they removed, the amount of delinquent rent that is owed, and contact information for the person that the tenant can pay the rent to. And it also has to include a statement that the property will be promptly returned on full payment of the delinquent rent. The next slide is just some of the things that they can take, or some of the things that they cannot take. I'm sorry. They can't take kids' toys. That doesn't include things that adults use, like Xboxes, PlayStations, gaming consoles. Those are probably going to be the first things that a landlord is going to take. They're going to take the high ticket items, the nice TVs, the PlayStation 5s that cost $500, $800. I don't know how much they cost. They can't take food. They can't take your kitchen furniture. They can't take important documents. They can't take clothes or school books or family portraits or pictures. They can't take medicine. I have had some clients who their landlords executed a landlord lien, and they did take things like their social security card or their insulin that they needed. And that is not, those are things that the landlord cannot do. He cannot take those items. So the next slide is going to talk about when the landlord does violate a landlord lien. If they or their agent violates this, then the tenant can file a lawsuit. They can get the actual damages. Say the landlord takes that property and they sell it, but the tenant paid their rent, so they shouldn't have sold it. They can get the actual damage of whatever the property is worth. They can get their property returned to them. They can get 1 month's rent plus $1,000 minus any costs owed to the landlord and reasonable attorney fees. The next thing that I'm going to talk about are security deposit. And I'm sorry, I did not include the property code section on here. I will have to look that up and I'll send it out in an email so Maricela can send it to you guys. But for security deposits, this is like a pot of money that the tenant gives the landlord for their security deposit. It's usually 1 month's rent. Sometimes it might be 2 months rent, just depending on the landlord. But once a tenant moves out of the property or they're getting ready to move out of the property and they want to get that security deposit back, I always tell them that they need to make sure that they clean the property. It needs to be broom swept. Clean the carpet. It's always cheaper, I think, to get the carpet cleaned yourself than wait for the apartment complex to come and try to charge you $300 to clean carpet that you probably could have paid $75 to get to clean professionally. But if you're moving out and you want that money, you have to give your landlord a written forwarding address. It has to be in writing, and you have to give it to them because they need an address of where they need to mail your security deposit. And then you have to surrender possession. And this means you actually have to move out of the unit and you need to return the keys and security devices. A lot of times people are still in the unit, they still have belongings in the unit, and they're trying to get their security deposit, and they're not going to get that back unless they actually move out and return those items to the landlord. Once they do that, they've moved out, they've cleaned the property. I always recommend that they take a video recording of how the property was left. So that way, you know, the landlord can't say that they trashed it. They have their own pictures of how the property was when they left. A video or pictures, either or both. Once they do that and they've given the written notice to the landlord then has 30 days to either refund their deposit or provide an itemized accounting of all the charges that were applied to that tenant, or all the charges that they took out of that security deposit. So say your security deposit was $1,000 and they returned only $500. They have to provide you an accounting of why they kept the other $500 of your security deposit. If for some reason a landlord does not return your security deposit within 30 days or provide you an itemized accounting of why you're not getting your security deposit in 30 days, then the tenant can file a lawsuit in JP court, of course, to get that security deposit returned back to them. And the tenant can also ask for 3 times the amount of the original deposit plus $100, court costs, and attorney fees. So if you have a $1,000 deposit, you moved out, the apartment is in pristine condition, you gave your landlord a written forwarding address of where they can mail your check, and 30 days has passed and they haven't sent you anything, you can file a lawsuit, and that $1,000 security deposit is going to be multiplied by 3 plus $100. So your $1,000 security deposit, you can get a return of $3,100 from your landlord. So that's a really good thing, I think, for tenants. The next thing we're going to be talking about is discrimination. And discrimination, there are a couple of different provisions. There's a property code, there's USC, there's a Dallas City Ordinance, and there's the Fair Housing Act. So just kind of a brief overview of discrimination. The Fair Housing Act does have some exemptions. For a single family home rented without the use of a real estate agent or advertising, as long as a private landlord or owner doesn't own more than 3 homes at the time, those people are not subject to the Fair Housing Act. If there's an apartment of 4 units or less, if the owner lives in one of the units, those are exempt from the Fair Housing Act. Or if you're renting a single room in a house, those do not are exempted from the Fair Housing Act. So if you have an owner that has 5 homes, they are subject to the Fair Housing Act. If you have an apartment building that has 5 units, they're subject to discrimination. Or if you're renting a whole home and the owner has more than 5. Housing discrimination is discrimination in which an individual or a family is treated unequally when trying to buy, rent, lease, sell, or finance a home based on certain characteristics such as race, class, sex, religion, national origin, and familial status. That's the Fair Housing Act. The next slide just gives you a kind of overview of the protected classes. And in Dallas, sexual orientation is a protected class under the Dallas Ordinance. Some groups that are not protected, voucher recipients, people with criminal backgrounds, people that are homeless or people that don't have a rental history, people with bad credit, or people with past evictions. If a landlord chooses not to rent to any of these groups of people, that would not be a violation of the Fair Housing Act. The next thing I want to talk about is cash rental payments, and that is covered by section 92.011 of the property code. A landlord must accept a tenant's timely cash payment unless the written lease agreement requires the tenant to make a payment by check, money order, or other traceable or negotiable instrument. So if the lease agreement is silent on how rent has to be paid, the tenant can pay the landlord in cash and the landlord has to accept it. For landlords who receive cash payments, they have to provide the tenant a written receipt, and they have to enter that payment date and amount in a record maintained by a landlord. So they basically have to have a receipt book or a ledger. The problem is that if you can imagine, a lot of times when people pay cash, their landlords are just taking that money and they are not giving receipts. Or maybe they'll give a receipt here. Next month they want, the month after that they'll give a receipt. Or maybe they're just not keeping a ledger book at all. If a tenant pays the landlord in cash and the landlord does not give them a receipt and keep an account ledger, the tenant can file a lawsuit in JP court to recover court costs, attorney fees, and the greater of 1 month's rent or $500 for each violation. So each month that the tenant pays in cash and the landlord doesn't give a receipt is a separate violation. So if you have a tenant that is in a year-long lease agreement and they pay cash all 12 months and they never get a receipt, that tenant can file a lawsuit in JP court and basically ask the court for each one of their months of rent back because they didn't get a receipt from their landlord, or the landlord didn't keep a ledger as they are required to do so under the Texas Property Code. And this comes in hand a lot because there are landlords that will say, you know, this tenant didn't pay rent, and that tenant will say, yes, I did. I paid you in cash. And the judge is going to say, oh, well, where's your receipt? Well, if that landlord doesn't give a receipt, then what you would want to do is have the tenant file a lawsuit so you can have some type of evidence or proof that I did pay my rent in cash and they just didn't give me receipts. That's why I can't prove that I paid my rent, because he didn't give me a receipt. So I've used this a couple of times and got people a pretty good chunk of change because their landlords just didn't know better and they didn't give them receipts. The next thing I'm going to cover is evictions. And I actually do a whole hour-long presentation over just eviction. So I'm going to try to cover it in about 10 minutes so that I can leave 10 minutes for you guys for your questions. So I'm sorry if I'm zipping through all this. I apologize. But evictions, they are covered by Chapter 24 of the Property Code and the Texas Rules of Civil Procedure, Rule 510. Just a quick overview of the eviction process. The landlord has to give a notice to vacate to a tenant before they file an eviction. That notice to vacate can be delivered via mail. It can be hand delivered to someone older than 16. It can be posted on the inside of the front door, or if they're going to post it on the outside of the door, it has to be in a sealed envelope marked important documents. And it also has to be placed in the mail the same day that they post it on the outside of the door. The length of the notice to vacate is going to depend on the lease agreement. If the lease agreement is silent, then the property code says they have to give you at least 3 days. The TAA lease agreement, it only gives tenants 24 hours. So after that notice to vacate is delivered to the tenant, and the tenant doesn't move out, then the landlord's next step will be to file an eviction lawsuit in JP court. And that eviction lawsuit is going to be heard within 10 to 21 days after the landlord files that lawsuit. There will be a hearing. If the tenant loses, he can appeal. And if the tenant wins, the landlord can appeal. So either party can appeal that judgment within 5 days. And those 5 days do include Saturdays and Sundays. So it's a very, very short deadline to appeal an eviction judgment. A tenant can appeal their judgment if they lose by posting the appeal bond, which is usually set at 1 month's rent or 2 months' rent. Or they can file a statement of inability to pay, which should be at each courthouse. They should have a blank statement of inabilities for tenants to fill out. If the eviction is for a non-payment of rent case, you have 5 days to appeal with a statement of inability to pay, which means you wouldn't have to pay the appeal bond. But non-payment of rent cases, once you turn in your statement of inability to pay, you have 5 days to put 1 month's rent into the court registry if you want to stay in the property while your case gets appealed to county court. If you don't want to stay in the property, but you still want to appeal your case, you don't have to pay that 1 month's rent. If the eviction is for a lease violation, all you have to do is file your statement of inability to pay, and your case automatically goes up to county court. You'll have a hearing in county court. It's always recommended to have the tenant file a written answer to their eviction, because if there is no answer on file once they get to county court, then a default judgment could be issued against that tenant because they didn't have a written answer on file. So always give your tenants a written answer. It can just be a general pro se answer. For all evictions, the tenant should continue to pay their rent into the court registry as it becomes due. Tell them don't pay their landlord, go to the courthouse and pay your rent into the registry, because the court is basically going to hold all your tent or all your rent in an escrow account for you. So when you go to your county court hearing, the judge is going to be able to look in the system to see if you have been paying your rent into the court registry. If you don't pay your rent into the court registry within those 5 days, or if you miss a month of rent that should be in the court registry, a writ of possession can issue. And like I told you guys beforehand, a writ of possession is basically a written court order signed by the judge directing the landlord to remove you and all your property from the unit. If the tenant is on any type of subsidized housing and they only have a portion of the rent that they are responsible for, then they are only responsible for paying that portion. So say their rent is $500, but the tenant is only responsible for paying $100. The judge should set that a bond amount at $100, and the tenant should be paying $100 into the court registry each month, not $500, because that other $400 is not their responsibility to pay. And if the judge for some reason says, no, that tenant is responsible for $500, then there's a way that you can contest that amount with the court. I told you guys about a writ of possession. For an eviction to happen, there has to be a landlord-tenant relationship. Title cannot be at issue. If title is at issue, then the eviction needs to be dismissed. And you can do that by a plea to the jurisdiction or an abatement. And then you would have to go to district court and file whatever type of lawsuit, basically to duke out who is the rightful owner of that property before the rightful owner can then come to JP court to evict. So title cannot be at issue. If there's a husband and a wife and they're getting divorced, but the property is in both of their names, neither party is going to be able to evict the other party from the residence. They're going to have to settle that outside of eviction court. And then once a rightful owner is determined who has, the right of possession, then they can come back to eviction court and evict the other party. For evictions, the landlord has to sue and serve all the tenants on the lease agreement. So if there is a husband and a wife and they are both listed as tenants on the lease agreement and not just occupants, If the landlord wants to evict both of them, then they have to file an eviction and they have to serve and name both of them. If they only name one of the two, then that other tenant is not going to be evicted. So say they file the eviction against the wife and not the husband, they would be able to evict the wife, but they wouldn't be able to evict the husband. There's no counterclaims in an eviction lawsuit. You have to file a separate lawsuit. Also, you have to get permission to do discovery in JP cases. So if it's an eviction case, you can't just send the other side discovery. You have to get permission from the judge before you send the other side discovery. Just some common defenses to the normal eviction. If the tenant did not get a notice to vacate, that's a prerequisite to file an eviction. If the notice to vacate was improper, if they cannot prove delivery of the notice to vacate, or if it was premature delivery. If your rent is due on the 1st and they gave you a notice to vacate the day before rent is due, then that would be premature notice to vacate. You can't say that I owe rent before rent is actually due. On the flip side, there's a premature filing. So say in their notice to vacate, they said, we're going to give you 10 days. If you're not out by 10 days, then we're going to file an eviction lawsuit on that 11th day. If the landlord then comes and tries to file an eviction lawsuit on the 5th day, instead of giving you the full 10, then you can have that case dismissed because they filed their lawsuit prematurely, because in the notice they said that you had 10 days and they only waited 5 days. For manufactured homes, there is an opportunity for a tenant to cure delinquent rent that has to be sent out. We don't see that a lot, but sometimes it comes up. Retaliation and discrimination are affirmative defenses to an eviction that have to be pled. Retaliation comes into play a lot when tenants are requesting repairs be made and the landlord gets mad, or the tenant calls code compliance and code compliance comes out and fines the landlord and the landlord gets upset. Or one time I had a tenant that actually called the police on his landlord, and the landlord got upset and tried to evict my tenant. We use retaliation as a defense. Anytime the tenant tries to exercise a right under the lease agreement or any law, the landlord has a 6-month window where they're not supposed to retaliate against you. So say you do a repair request on Monday saying, I need you to fix my toilet. The landlord gets pissed off, and then on Tuesday, they give you a notice to vacate. You can use retaliation as a defense and say, the only reason why you're trying to evict me is because you're mad at me because I asked for you to make this repair, which is allowed for me to do so under the lease agreement and the property code. Also, on the same side, discrimination. If you file a discrimination complaint with fair housing for discrimination, then you basically kind of have 2 defenses to your eviction. Your landlord is discriminating against you, and your landlord is retaliating against you because you filed a discrimination complaint against them. So those are some defenses. Some more defenses are if the tenant is in public or federally subsidized housing, like a voucher, if there's a lack of a serious lease violation. Unclean hands and equity. I see this a lot with tenants say they ask for repairs. The landlord is upset. They go to pay their rent on the 1st, cash in hand or money order in hand to pay their rent. And the landlord is upset, so the landlord doesn't take the rent. Or the landlord locks them out of their tenant portal so they can't pay online. What I tell people is, keep that money order. Don't cash it. Don't put it back in your bank, because the judge is going to want to say, well, why didn't you pay your rent? And you can say, well, I have this money order and they refused to take it. I literally had it in my hand. I tried to give it to them and they told me no. Or tell them to take a screenshot of when they go try to pay their rent on the portal. This landlord is mad at me, so they locked me out of the portal. So I physically could not pay my rent. And that's the only way to pay rent is through the portal. So that's unclean hands. The landlord can't say, oh, you didn't pay your rent when they actually refused to rent. Of course, payment of rent is a defense to a non-payment of rent case, and this is an affirmative defense that would need to be pled. If the tenant signs a new lease agreement, then the landlord cannot evict them for anything that happened under that previous lease agreement, unless the new lease reserves or has a provision in it that says the landlord can do so. There's a 2-year statute of limitations for eviction cases. One defense is unequal treatment by a public housing authority. That's what PHA stands for. Promissory estoppel, family violence. If someone is getting abused at their unit and they're a victim of family violence, then the landlord cannot evict that victim of family violence. There's also a bankruptcy eviction. Once a bankruptcy is filed, you guys know about the automatic stay. It basically stops the eviction right then and there. But that's usually brief. The next thing is for the lease violations, it's really hard for landlords to prove assaults and criminal activity unless they have witnesses to the event. If the landlord is just there in court saying, oh, well, tenant A told me that, this tenant got into a fight, they have no personal knowledge. And if they don't bring tenant A to testify, it's going to be their word against that defendant's word. So it's really hard for them to prove that without witnesses, and you can get cases thrown out for lack of personal knowledge. The tenant can also request that a county court judge appoint them a free attorney in writing. The county court judges aren't going to approve that always, but I do know a lot of county court judges will give tenants a free attorney if they are going up against the housing authority, or if they're disabled or there's a special circumstance why they think that that tenant should have a free attorney in their eviction case. And you would just make that request in writing and submit to the court. I always tell people that if they're going to represent a tenant in an eviction case, they always need to file an answer and request for attorney fees, because the judge can award attorney fees in an eviction case. So why not ask for them off the top? There's some miscellaneous things that I won't cover because I want to allow you guys time to answer questions. So I'll stop sharing and I'll try to go through these questions in 6 minutes. Okay, so the first question was, since it offers you tracking, what are the downsides of using email to make repair requests? Emails need to be in writing, like physical writing, not emails. If the lease agreement says that you can do it via email, you can do it. I always prefer to do a certified mail return receipt request because you only have to send that one request. Yes, you guys will get a copy of the presentation. How quickly must a landlord repair a broken hot water heater or provide hot water? So the normal repairs are between the 7 to 10 days, but things like hot water, a broken toilet, say you're in a 2-bedroom apartment with just one bathroom. If your one toilet is broken, then they should make that repair pretty quickly. I would say within 24 to 48 hours. Now, if you're in like a 2-bedroom, 2-bathroom apartment and one toilet is broke, but the other toilet is working, then that toilet that's not working, they would have 7 to 10 days repaired. But for things that are really quick, I would give them a 24 to 48 hour window to make those repairs. Is there a set time frame for how long a client has to move out after terminating due to failure to pay repairs? There is no set time frame, but I would do it really quickly. If you're terminating the lease agreement because the landlord is not making repairs, You're basically saying, I can't live here because you didn't make this repair. So it really doesn't make sense for the tenant to stay a whole extra month. I would say that the tenant needs to be ready to move out within a week or two. What happens if a tenant makes repairs and also pays rent? Can the tenant get repaid for costs of repairs? So the problem with that is that you can ask the landlord to basically give you the money back. Some lease agreements say that you cannot make changes to the unit. So you would need to read the lease agreement to see if they're allowed to make any type of changes. And sometimes repairs might be actually changing the unit. If the tenant makes those repairs and then the landlord doesn't want to recoup them or basically pay them back for the money, then the tenant would have to file a suit in small claims court and say, hey, I made these repairs to your unit and you didn't pay me. So that's the answer to that question. The next question is, it's not clear from the statute when you need to terminate your lease due to repairs. I have provided termination dates in my termination letters and accepted the prorating of the rent. Thoughts? I think that's fine. Like I said, I wouldn't stay past 2 weeks if you're going to terminate the lease agreement for failure to make repairs. Definitely don't stay a month. Tell them they need to go ahead and move pretty quickly. Let's see. The next question is, do TAA leases typically have a clause for terminating utilities? Yes, of course. The TAA, the Texas Apartment Association, they have a lot of money. They have a lot of people that lobby for them on their behalf because they have a lot of money. So they are going to have all that in their lease agreements. The next question is, does promptly returned mean the landlord has to deliver the items back to the apartment or just make them available? I think they just have to make them available. It would be nice and courteous of them, of course, to return them back to the unit. Section 92.102 for security deposits. Thanks, Mr. Holmes. How much detail does the security deposit does the itemized accounting require? Basically it needs to have a list of, carpet, $300. If they're charging you for trash removal, it needs to say trash removal, $100. It needs to basically account of why they're keeping that security deposit. So they need to have what they're keeping it for and the amount that they're charging. Can you please let me know where I can download a copy of the PowerPoint slides? I think they're going to be emailed to you guys. Is permission for discovery necessary when the eviction is appealed to county court? No. So once the case gets appealed to county court rules apply, or the regular rules apply. There are some judges sometimes that will say, oh, I'm going to apply, the JP rules to this county court case. And I think that's really weird. And you might just have to educate them that no, once it gets appealed to county court, it's just like all the other county court cases. And I think that was all the questions in an hour. Did you guys have any other questions for me?